of law and society can more be clarified when we think of why some laws fail and why some few laws succeed and why few laws are resisted. There have been laws, for example, Nirbhaya ordinance or amendments moved post Nirbhaya incident were readily accepted by the society. However, when it came to framing of certain laws like C.A.L. or Citizen Amendment Act, we found some resistance in the society. Sometimes we see that laws are completely failing. Initial years of dowry prohibition law, medical termination of pregnancy laws, they were failing. Uh, Another example of law failing would that be India is considered one of the largest consumers of child pornography. We have very stringent laws under Information Technology Act. Then why is that Information Technology Act is failing? There must be some reason for that. Uh, Despite having very stringent laws under POCSO, under IT Act, under IPC. So when we make a law, the law has to be very real, very effective, very humane, and very much reform oriented. That is what we expect law has to be. Only when law satisfies these things, it would be readily accepted by the people, it will not be resisted, and it will be effective. It is Besides this, it is true that legal cultures also affect the developmental process or development process in transitional societies. So if we have a good legal culture, it will play a very crucial role in the way a transitional society develops from and it transits from one phase to another. So if I have to summarize what I have said till now, is that because we academicians, we lawyers, we law students, we are very much accustomed to looking at legal research only from legal lens, from law's sense. And we have plethora of evidence in the history that says that laws per se are just black letters. Laws, if you just read out and believe only in statutes and precedents, it's not going to work. Society is run through social rules that take care of social good. And law can only be a factor that helps in those in enforcing those social rules. So law in sense of state law being backed by the institutions and organizations of the state can contribute to the achievement of social goods. In developing this analysis, we need to break law into two different kinds of law, such as we can break into civil, criminal, constitutional, etc. And lastly, that when we have a state law, it definitely has some advantages with us. So can law be studied just from law's angle, law's lens? The answer is, or if the legal research can only be done from the interpretations of law, the answer is no. Social realities, social rules are important because they shape law. But that also does not mean that law does not have any significance, because law has acted as a tool of social transformation. And just few minutes back, I told that legal cultures do affect the development process in transitional societies. What could more be justifying than this, to undertake a socio-legal research, right? Uh, I am not saying that all the researches have to be of legal research in nature, even though so much convincing and justifying it sounds so. No, that is not the case. It is up to the researcher, up to the research objectives that he wants to achieve, then he can take it up. Now, coming back to the definition of socio-legal research, of which we were all awaiting. Socio-legal research is an interdisciplinary approach that examines law through social lens. It investigates how legal rules, institutions, and processes interact with social behaviors, norms, and structures. Unlike traditional doctrinal research, which focuses on black letter law, socio-legal studies use empirical evidence from social sciences to understand law's real-world impact. So I've just now read out to you the definition uh, of uh, 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 social science, socio-legal research, and yeah, maybe I can share PPT with you also. I can share some slides with you. So this is what we have come to as of now. When we conduct legal research, traditionally, we used to stick to doctrinal methods. We academicians, we law students, we lawyers, we professionals in law, we used to stick to case laws, sections, case commentaries, uh, law commission reports, newspapers, letters, mostly doctrinal research. As socio-legal research started getting popularity and acceptance, we started trying to look into what social sciences are doing. Well, social sciences are also not aloof from these methods of research. They too were mostly into doctrinal method. Quite later on, in the 19th century, they realized that the research in social sciences has to have positivist approach, empiricist approach. And slowly they started borrowing methods of research, tools of research, approach of scientific research from natural sciences. So they assume that the way natural sciences are being studied, researched, they are studying in laboratory, there are various scientific methods that they are using. Social sciences also needs to be studied in a scientific manner. And nomothetic, they called it nomothetic approach. So social sciences started relying upon research methods that were scientific in nature. And when law wanted to borrow and include social sciences, because social sciences was already borrowing scientific research methods, scientific approach, law also accepted this approach. And socio-legal research, as a result, as of date, what we see is mostly is conducted in empirical manner. It has got doctrinal approach and it has to have non-doctrinal approach. So in this session, you would have few takeaways from this session. One of the takeaways I want you people to have is that socio-legal research, if you are doing, you must do an empirical study. You need to have the component of empirical study. You need to have non-doctrinal as far as doctrinal. You cannot have just doctrinal. You cannot have just non-doctrinal approach. You need to have both of them. Now, when I say that there has to be an empirical approach and an empirical element, non-doctrinal element to it, the question is, what approach should we take up? Should we take up inductive approach? Should we take up deductive approach? Is there some law for it? No. Of course, few studies might need inductive approach, but mostly what have we have seen is that socio-legal research is conducted from deductive approach. What is deductive approach? Deductive approach take the steps. Deductive approach is an approach which moves from more general to specific. Now, what is this general to specific? In a deductive approach to research is the one that people typically associate with scientific investigation. Number one. Number two, they start with social theory that they find compelling, and then they test its implication with data. Okay. So first you take up a theory and then you start collecting the data. Then whatever the results that you get from the data, you apply those results to the theory and you come to a conclusion uh, whether the theory is true or not. I mean, you must have framed your hypothesis also. So whether the theory exists, is that the case or not? Or the theory needs to be changed. Could the theory predict the facts? This is the question that you have to ask yourself. You have a theory, you believe in the theory, you start collecting the data, and by the end of the data, you investigate. By the end of data collection, you analyze the data, you interpret the data, and you come to a conclusion and you verify, cross-verify whether the theory existed there or not, whether it's true or not, or whether it has undergone any change or not. So researcher studies what others have done and they read existing theories of whatever phenomena is there, and then they test the hypothesis that emerges from those theories. This is called as deductive approach. Popularly, I'm not saying in all the socio-legal researches, but popularly deductive approach would be taken. What's a deductive approach? We have just now said it goes from general to specific. You have a theory to begin with, and then you collect the data and you test whether the theory was right or not. Inverse is inductive approach, where uh, it is just exactly opposite of deductive approach, where the researcher first collects the data that is relevant, and then after the substantial data is collected, then they look at the patterns in the data, and then they develop a theory from that which explains those patterns. Okay, so that is inductive. Here, what we have discussed for significant period of time was deductive approach. Now, I'll just check if I could share yeah, I can share. Great. Yes. Yes. I guess the slides are visible. Yes. I guess the slides, yeah, participant can see you. So, we have discussed the introductory part, uh, understanding the fundamental questions of uh, does law change society or society changes law. We have discussed law as a social phenomena. Law, because being social phenomena, uh, we can't say that uh, you know purely legal research would satisfy. No, research methods. Yeah, this is this is very crucial. This is very crucial to see. Is this also we have covered? Yes. Now we need to understand, generally in any topic of discussion, it is important to understand the history of of uh, of the phenomena. So if social research, as socio-legal research, if you have to trace back the history, I the available literature says so, but I can trace it way back also. But since the popular literature on this tells us that in early 20th century there was a legal realist movement wherein which was shaped by US judges, and they did a lot of empirical studies as to how judges were delivering judgments in socio-political context. That was considered as one of the earlier examples of uh, socio-legal research. Then if we go back to uh, if we go back to 1960s, 1980s, we all know that there was feminist and critical uh, theory or approaches, feminist or critical theory approaches. uh, they had the perspective of social inequality. Their all research started from this question as to why inequality exists, and to comment successfully upon that some inequality exists. It cannot happen unless you do some empirical research, you go to the field, you collect the data. So they collected the data, they had an evidence that there was inequality in gender, there was gender inequality, and as a result of it, now what can be done in law? So it can't get more classic socio-legal research. We have inequalities in the society evidenced, and we have laws, and we are understanding, despite having so many laws, why it is not addressing the inequality. What change can we make in the law to address this inequality? And that is what all critical theory approaches, feminist theory approaches have been. Are there any, of course, in today's world, we see climate change, we see victim compensation. I'll get back to a few more examples in today's world. How social sciences are playing a very crucial role in understanding law. See, one more takeaway that uh, I want you people to have from this session is that we need to understand law is dynamic and society is also dynamic. Always there can be a cat and mouse happening between them. Sometimes, well, hardly we have seen law uh, going ahead of society and social norms. It is always law has done the catching game. But especially in case of technology, where technology is changing social norms, social patterns, social behavior, technology itself grows at so fast pace that it's really difficult for law to catch it. But society is dynamic, law is dynamic, they are not stagnant, but at the same time, they are supposed to hold on to each other for social good and social welfare. And which is good for us, for we researchers, because then always we can point out the gaps in the law. We can point out the gaps, uh, how law is regulating the society and how society is impacting the law. When we do a socio-legal research, is there a law that says it has to be doctrinal? No, there is no law as such, But if we look at the accepted methods of research, they say that a socio-legal legal research has to have an empirical aspect to it. And when we say empirical aspect to it, we have qualitative methods with us and we have quantitative methods with us. Okay. I'll quickly go through what these methods are. So when I'm talking about research methods, qualitative and quantitative, I am talking about how can you collect data, qualitative data and quantitative data for conducting your research. If you all remember a few minutes back, I just said that uh, I said that it's a deductive approach. We take a social theory and we test it. We take some theory and we test it. So testing happens by collecting the data and applying that collected data after analyzing, interpreting it, generalizing it to the theory. How do we collect this data? What is the nature of the data that we collected? So it can be qualitative, it can be quantitative data. What is qualitative data that we can collect? We can collect qualitative data with the help of interviews, uh, with the help of focus group discussions. I did a research on whether there is necessity of all women police stations in the state of Maharashtra. We interviewed, my field investigators interviewed around 600 policemen in the state of Maharashtra. And we all were interviewing them. Interview has got, you must have learned in your research methodology classes, open-ended interview, structured, semi-structured interview. The way you want to structure them, you can do it according to the needs of the research, but you can collect qualitative data from interviews. You can do focus group discussion. What does focus group discussion means? Focus group discussion means it's a group of stakeholders, right? If you are doing a research on victims of domestic violence, and if it's possible for you, then maybe you can have a group of victims sitting together. You can have policemen who handle the cases of domestic violence. You can have a group of 10 to 15 lawyers who are defending the victims or who are defending the accused. It's okay, that's fine. There's a group of 10 to 15 people. You prepare a set of questionnaire and you start the conversation, and you will realize that you just throw a question in rolling, it is picked up by the stakeholders. You have to engage the stakeholders in the conversation, and you have to observe and you have to gather what they want to share. You take all that information and then you try to analyze and interpret what the data, what they have spoken about, how have their lived experiences been. Yes, you interpret and you draw some inferences from their data. You can draw some findings from those discussions. Imagine 15 lawyers who have been defending victims of domestic violence. They'll all tell uh, what is how police responds, how victims responds, how generally the accused are, what kind of judgments the judiciary has been giving, how sensitive media has been towards these situations. So focus group discussion is very crucial, and it is at the end of the day nothing but, in a simplistic form, I'm telling, considering the paucity of time, is you have a group of 10 to 15 people. You have some points ready with you, some questions to be rolled out, and in their from their discussion you gather. Third type is content analysis. We have content generated in media, we have films. You go through the content and you try to understand from that content what situation, what is the social dynamics. uh, Fairy tales that are told, even that can be a good content for content analysis and give you a good qualitative data. Uh, I would say, even the this is my take. The texts that are read during or recited when you are performing puja can also be a good text for content analysis. That also tells about how the society has functioned or worked at one point of time. Uh, Ethnographic is also another good qualitative method. There are many qualitative methods to collect the data. These few are popular. Case study is also one of the popular method of uh, collecting qualitative data. What is case study? Case study is, let's say there is a victim. In a very simplistic manner, I am putting, there is a victim, and see, I was doing research on victim compensation law. Do you think we can study about victim compensation law in the state of Maharashtra or India just by reading uh, the effectiveness of victim compensation law unless we interview, unless we meet some victims, right? So case studies, what do we do in case studies? You come across some victim, maybe who has applied for victim compensation, maybe who has not applied for victim compensation, and you ask him that there is a victim compensation law, what do you have to say about it? Can you tell us something about it? And he keeps on telling you. You don't have to ask further question. He tells his entire story, and that he himself becomes a case study for you. You take out the relevant content from whatever he has said and you record it and you put it in your research. Okay, so case studies also is also very gaining very much a popularity, and all the socio-legal researches that I have come across, uh, funded by these agencies in India, they have this component of case study. You need to have interviews, you need to have case studies, you need to have qualitative data is what I'm trying to say. You need to have qualitative data. Then quantitative methods, of course, they tell us about what and how much we can crunch them in numbers. Some of you might say, sir, can't we crunch qualitative data into numbers? Yes, we have got those softwares where we can do it. But quantitative data is outrightly very statistical in its nature. We can collect surveys, we can collect large samples. I remember that when I was conducting a research on whether social media companies in India follow data protection law or not, privacy policies, privacy law or not, we had collected data of more than 1,500 people, I guess. And it was a survey that we did. You frame certain questions, you and you collect data from not many people. It has got, surveys are generally very broad. You collect data from people, and you try to understand, you frame the questions in such a manner that can be measured on some scale. So for example, do you feel you are you get grievance redressal when you are on social media? Do you feel that your data remains protected when you are on social media? And the options that you can put for them is, I strongly believe it is safe. I moderately believe it is safe. Uh, well, sometimes I or I disbelieve, and I moderately disbelieve, and I strongly disbelieve. So there are various scales on which you can collect the data from the people. Uh, you can analyze how different stakeholders have difference of opinions. So for example, in this study, Um, uh, now, uh, in this study, now we had different stakeholders' opinions that were not matching each other. Police, they would say something. Lawyers, if collectively, if we look at their opinions, it would be different. Privacy advocates' opinion would be different. Victims or social media users' opinions would be different. So you can do a study amongst these various stakeholders. And after doing a study on these various stakeholders, then you can make some suggestions in legal reform, where law is falling short or law exists. For example, now in this, there was this study, as I right just few minutes back mentioned, we were doing a pan-India study that whether a user of social media feels safe when he's on social media, whether does he think that his data privacy would be there, does is there an efficient grievance redressal mechanism? We came to know that grievance redressal mechanism exists with all most of the social media, but then they it's not difficult. It is difficult for the users to access to that redressal grievance redressal mechanism and to get their grievance redressed. So, is there a law that says there has to be a grievance redressal mechanism? The answer is yes. Do social media provide grievance redressal mechanism? The answer is yes. But is it easy to access it? The answer is no. Are the grievances redressed? The answer is no. Majority of them, they say no. Now, here lies a stark difference that there was a societal need, there was a law, the law was there, and it's still not taking care of the societal need. So you have never come to know about this gap had you not done an empirical research, right? And uh, these days, popularly, what people are trying to do is they're trying to compare two different sets of data. They are trying to compare the judgments given by the courts along with census survey. So what you do is you have two different types of data sets. You can have judgments. You can have your own data collected through interviews, and you can have some published reports. And you try to compare these with each again, so with each another. It's a very interesting new kind of research, new kind of method that people are doing. Talking about newer methods of research, what people are these days doing is that earlier we used to, to do a qualitative analysis or to do analysis of content analysis of judgments. People used to sit and used to read over the judgments. These days, they are using artificial intelligence uh, to load the judgments and after that uh, give them keywords to understand how the judgments have been delivered, and of course there is a human oversight over this, but AI is playing a very crucial role when it comes to classifying the text, so whether a judgment is a feminist judgment, it's a feminism pro judgment, or is it not a feminism pro judgment, this AI tells you. So what you do is, it's a very interesting research that people are taking up. What you do is you download some 1,000 judgments, you tell the AI as uh, to classify the 1,000 judgments into either they are pro-feminist or not, either they are socialist or not, or which way they are swinging. Are they capitalist judgments or not? Maybe there could be any factor. I'm just this is a hypothetical thing that I'm telling you. And then you tell the AI uh, to bold or paragraph or to cite the reasons because of which he distinguishes judgments into 2 or 3 different categories and the relevant paragraphs, and then you make some human do overseeing of that. The AI will distinguish these judgments. Once it has distinguished, you sit over there, you just have a human oversight whether the AI has hallucinated or not, because AI does that. And then on the basis of that, you can come out with your research results. You can save money, you can save your energy. A lot amount of data can be scrutinized, analyzed with the help of AI. And people are developing, how people are doing research on electronic commerce. They are generating demo websites, demo e-commerce websites, and they look at the traffic that the demo website gets hit with, uh, and accordingly they draw the results. They're using technology like anything to track behavior of consumers on electronic e-commerce websites. People are doing participatory and community engaged research. So what earlier used to happen is that we as a law student, we as an academicians, we as a legal researchers, we used to go to the community, we used to observe them, and we used to jot down as to what is happening with them. Let's say tribal rights. You go to them, you observe them, you speak to them, you collect data from them, you come back home in your law school, and then you write a report saying that, okay, these are the laws, and this is how they are facing the problem. We legal researchers, we think that this is how the law is to be changed. This approach is going now. What is the approach that is coming is that we legal researchers, we law students, we sit with them. Whosoever is your community, it can be victims, it can be children, it can be anyone. We sit with them and we participate with them, and we then develop the model. We are not ourselves just doing it. We are making them a part of this framing of framing of draft policies or draft laws. Uh, uh, there, and then we show them something. I don't know. If I have to. Uh, I don't know. Let's say this Maratha agitation that happened. Uh, it's a very crucial. It was a very crucial factor of debate. And the last day of this agitation, on the last day of this agitation, what we witnessed was dramatic series of events. A government resolution getting passed, and it being considered by few as a victory of the agitators. What, as a socio-legal researcher, or as a legal researcher, what we could have thought, or what we could have done, is that we first have a draft of that resolution. We give it to the we give it to yeah, we give it to the people concerned. We have a discussion with them, and then we alter the draft, and then we have a final draft of the resolution. That could have been that could have been the way it could have we could have sorted that thing out. This from very research and very an academic oriented approach. You might have difference of opinion on this, but that's fine. And coming towards the end of the session, of our online session, is that whenever we are doing this kind of research, it is very, very crucial that we take care of limitations, we take care of challenges. And of course, money is a big challenge, because you cannot do an empirical study without money. You need to have time, you need to have people, you need to have resources, you need to have money. So it is one of the challenges, the real challenge of conducting this research. But then, besides this, if you are doing research on child sexual abuse victims, uh, the sensitivity of the data is important. The data is very sensitive. We need to be very careful when it comes to the consent mechanism while collecting that data, while preserving that data, while processing that data. When we are handing over the data to a third party, to a statistician, let's say, we have to be very careful. Second, when we adopt a sampling method, there is a possibility that sampling error or sampling bias creeps in. We have to take care of it. There is no scope for sampling error or sampling bias. We are all humans. We might make mistakes, but we have to be careful. We have to be cautious. And we say it's an interdisciplinary study. Interdisciplinary study, the moment we say it becomes complex, which gets prioritized over what? Uh, we have to be very careful. How much legal doctrines can be taken as effective on society, and how much sociological factors can we take, uh, dismissing the law or accepting the law. We have to be very, very careful because it's an interdisciplinary approach when we study this. And uh, consent mechanism, of course, having an empathy is important, and ethical concerns when it comes to vulnerable population uh, is there. These are the weaknesses. These are the threats. Of course, socio-legal research gives us a rich contextual insights. It gives us inputs that can impact policy. And good thing is that we have got digital resources. It is easier than before to do a global collaboration. We have technological tools for analysis, uh, which are good things. These are opportunities. These are good things because of which social legal research has become easier. And utility of social legal research need not be debated upon. It can shape in policy development. It can do awareness. You can do a social legal research, you publish it in newspaper. It will educate, it informs public discourse, and it identifies systemic biases. It might promote inclusive policies. It might support vulnerable populations, and it addresses inequality and promotes access to justice for the marginalized groups. Uh, it can definitely lead to legislative reforms. We have seen many such researches leading to legislative reform. There is something called as India Justice Report. Vidhi does that. Vidhi Center for Legal Policy does a lot of research. Common Cause, they are doing a lot of socio-legal research. And when we go for socio-legal research, uh, we have to be very clear in our mind what is the question that we are trying to ask. It cannot be a pure question of law. It has to have an intersection of law with the society. And I will give you quick two to three examples of such questions of where the world is progressing, and we will come to our end. Uh, if you happen to get time, do go through Journal of Law and Society, and they have been writing on very interesting issues. One of the interesting issues that they have written in this year 2025, in the edition published in May 2025, was victim blaming as collateral damage, professionals on court hearings in cases of rape, assault, and fraud. So this was a study wherein they tried to investigate, if I don't know whether it's still showing on the screen, but this study investigates legal professionals' understanding of the attribution of moral guilt to the complainants in court hearings comparing rape, assault, and fraud cases. It's a very interesting study. Another interesting study that is taking is the gravest inefficiency of plea bargaining and the consequence for rehabilitation and reintegration. That they are saying that how supposedly plea bargaining was supposedly to be efficient can in fact obstruct and militate against the prospect of offender rehabilitation and reintegration. Uh, so this is another approach, another angle of study, and algorithmic facilitated discrimination, socio-legal study of use by employers of artificial intelligence in hiring systems is another very interesting. So artificial intelligence algorithms are deployed by the employers to filter out the applications that have been made by the candidates or prospective employees. They filter out these applications and then they conduct interviews. But how that algorithm can lead can be a cause of discrimination. Uh, and if that algorithm discriminates people, which it ought not to, uh, on the grounds where our constitution prohibits to discriminate, then we need to have a law saying that any entity who has an algorithm, who has an AI that is discriminating people on the grounds that are prohibited by the constitution, we'll take some action against them. As of date, do we have any law particularly addressing this issue? The answer is no. And this is another classical socio-legal research. People's applications are being rejected by the algorithm. They are not even told the reason for what it is getting rejected. Bias is being played against them. They don't have any recourse also. And of course, we do not have any law. And lastly, another example would be uh, uh, on a knife's edge, medical, police, legal responses to self-harming protesters. So when there is a self-harming protester in some there are the protesters, agitators. We have seen there have been not many agitations in this state itself. If they are self-harming, then what is the role of medical professional, police, and how should be the legal responses? So like this, there could be many interesting topics of socio-legal research. Uh, and I'll just check whether, uh, yes, I guess we are towards the end of our our session. I would be very happy to answer your questions if you have any.
Yes, sir. May I?
Yes, yes, please.
Yeah, good afternoon, sir. I'm Vishaka Patil,
Hmm.
uh,
Yes,
research
ma'am.
scholar. Sir, it has been told to us in your introduction that you have done research in the subject digital data and what cybercrime.
It did.
Yeah,
Yes.
just out of
Yes.
curiosity, I just want to know what was your finding and was it a doctrinal or non-doctrinal research?
Yes. So see, I have conducted two types of, I've done multiple researches on this topic. The recent one that I have finished doing was on data privacy, how the users of social media feel as to whether their data is protected by these social media giants or not. And this study was conducted in the background of
significant social media intermediary. That means if you are a social media having user base more than 50 lakhs, then you are supposed to follow some mechanism. This will ensure the data privacy of the people.
Right.
What we did was we interviewed the social media giants, we interviewed the users of social media, and we collected data from uh, privacy activists also. Now, at the end, what we have come to a conclusion, it was doctrinal and non-doctrinal both. We applied in non-doctrinal, we applied both qualitative and quantitative data. We gathered both types of data. We did case studies, we did focus group discussion, we did interviews, and we did conduct surveys also. And what we realized, there are three prominent things that we realized. One was that uh, the data protection laws of India do not classify social media intermediaries into foreign social media and Indian social media. And the set of rules that we have for both of them is same. From industry, what we got to know is that this, because of this, it is very difficult for Indian social media to compete with foreign social media. This is one of the reasons that we do not find a social media platform equivalent to WhatsApp. All the social media platforms that we are seeing in India, which are popular, are all from abroad. Yes, very recent, just yesterday or day before yesterday, Prime Minister Office, the Ministry for Information Technology said that we should promote Indian applications, Indian yeah, that is there. But then this is what we found out. Second, what we found out was that people exactly did not know what was the scope of their privacy. Uh, the third thing that we understood was that people have been very much uh, troubled with the way the grievance redressal mechanism in India works. Okay, if you have a problem with social media, if your picture has been posted by someone else on Facebook, the amount of trouble you will have to take that post down with Facebook is humongous. Most often people have lost their hope and they have stopped following Facebook as if they are not going to, take it down or something like that. So takedown of content is a problematic thing, not just for the users, but also for the police officers, law enforcement agencies. From law enforcement agencies, we got to know that, and this is cybercrime, by the way. I mean, many part of this is a cybercrime. That it is so difficult for them to take down the content because the number of permissions that they have to take from various departments and then to send out to the social media offices like Facebook or Instagram, it is very difficult. So that is there, uh, and are the crimes being conducted? Yes, social engineering attacks are on rise, and of course, all of us know that despite we have a cybercrime law, despite the growing awareness, the number of complaints that really gets reported uh, in police stations, in cyber cells are far less than the actual number. And most importantly, it is very uneconomical and it is very financially burdening or taxing activity for the law enforcement agencies to investigate the culprits. And because it's very economically taxing thing for law enforcement agencies, it dissuades them, it discourages them. You have lost 30,000 to to investigate a crime and to nab the criminal, maybe you will end up spending, most likely you will end up spending a lakh of rupees. And that will not make sense to law enforcement agencies. So unless you have a huge bank fraud, unless you have suffered a lot, they might not. Uh, this is what people have. This is what people have. All people have, shared. They might not act upon. So, um, do we need a data protection law? Of course, we need a data protection law. The rules are not there yet. People are not equipped to take DPDP law or to initiate DPDP law within their organizations. And the consequence of insignificant data breaches is very high as per the law. The last finding that I would share with you is that the consequence of insignificant data breaches is enormous. That means even if for a slightest of data breach that you have in your organization that leads to data leak of personal data of people, the amount of compensation that you will have to pay would be humongous. This is detrimental to corporations that are in India, but the foreign companies they can take up this. And they might be able to compensate, but for Indian companies, it will be very, very detrimental. The damages can exceed to 500 crores, something like that. It can just push the company into bankruptcy for an insignificant data breach. I hope, am I audible?
Yes, sir. Yes.
Yes,
Yeah.
yes.
Excuse me, sir.
Yes.
Sir, I am Yogesh Dabhade, LLM first year student, sir. I have one question. Sir, how
Yes,
can
yes.
legal and social structures be designed to prevent hierarchy and inequality?
It's a, yeah, no, this is a very broader and very broader a question. You will have to look at the context. And you will have to first understand why the hierarchies exist. Okay, it's a very context specific solution that you will have to find out. Why the hierarchies exist, and then why, to what extent law can operate as a tool to take care of the historical inequalities that exist. That is one, and till what extent law would be successful. When it comes to historical inequalities or hierarchies that we see, law has not. We cannot rely just upon law. There has to be some other methods also, and that is where socio-legal research is lacking, and that is what we all demand also. But it's a very context specific question, and you'll have to look into the very much relevant literature to answer that question. But of course, we have to understand the history of hierarchy in whatever context you take it. And then you have to understand the present situation, present context, and how the society is developing. What are the existing models to address that hierarchy or inequality in other states? How much they have been successful? What are the other schemes through which they have been able to take care of this? What do we, at the end of the day, want to achieve? Is a very crucial question that we have to ask us. What do we want to achieve? What do we want? When we want to address these inequalities, what is that we are wanting? And if we can't find what we want, or if we have no tool to measure whether that exists in the society what we are wanting, then law will not make any sense. Okay, so we have to understand what equality. If you are saying that there have been inequality, there have to be equality. what do you mean by equality and how will you measure it? That is the question. Unless you figure out that, our laws are of no help, because we'll keep on making framing laws, judiciary will keep on interpreting it, we'll have some resistance to it, we'll have some acceptance to it, it might fail also. So I guess uh, that last uh, narrative, that should be guiding our discourse. I guess I am hope I could hope I have answered your question.
Yes, sir. Thank you.
Yes. So a research objective would be very crucial in that. What is our research objective? Yes.
Any more questions? Because we are now asking them to submit the synopsis, and even the research scholars, they have to submit their synopsis by the 2nd of October.
If all of you are submitting synopsises, there is just one thing that I would request all the students and faculties to ensure, which is being looked by all the funding agencies, is that they look for research gap through your literature review. Something that we do not pay much attention to. Where is exactly the literature is falling short of addressing? That we have to find. You have to quote 15, 20, 25 different literatures, and you have to find out exactly where the gap exists, and you have to address that gap. That is one. And second, by addressing the gap, how are you promoting social cause? How relevant it is, how practical it is. So one of the reasons, and third thing is that when we frame synopsis and we submit a proposal to the agency, our research starts before submission of the proposal. So we literally start doing a pilot study before the submission of proposal itself.
I
So
don't
we
want
do
to,
not.
I just intervene here. Our PG
Yes.
students, they what they write that they have read the AIR and then some cases in the review, but they don't understand that the entire gist they have to write in the topic they have chosen, and they
Yes.
actually they don't know the idea of putting the literature review of literature in a proper way. That is their I guess big hurdle they have.
Yeah, we academicians also have to be a little bit blamed for this, because traditionally we have been interchangeably using literature review and review of literature. So people are just making a list of the literature that they have come across. That is very rightly pointed out by ma'am, that that is not is what is being expected from this from anywhere. If you go, that is not they want. They want to know a particular literature, why is relevant for your topic of research. You have to mention that this book is relevant for my research because my research is about this thing. This book also talks about this thing. However, this book does not talk about a particular thing on which I am researching. So I am moved to some another literature. Now this XYZ or this Y literature also talks about my topic of research. It does a doctrinal study. However, it does not address this particular factor in my research. And what you can do is you can also mention that the literature that I am citing over here, I will not completely rely upon it, because I think the methodology that was adopted by the author of the literature is something else. My methodology is something else. He conducted interviews. I would be doing focused this thing. His is a longitudinal research. Mine is not a longitudinal research. His is exploratory. Mine is action research. So not just upon the findings of the research, you can say that this research, even though is relevant for my research, and that's why I'm citing over here, but I say that there is a gap in the literature is because the difference in the methodology, the difference in the research methodology. They have used this sampling method. I am not going to use this sampling method. I am going to use this sampling method. So unless you have this factor in your research, I don't think it becomes a quality legal research. There has to be a gap in literature. You can justify it in the manner of the methodology. You can justify in the manner of the stakeholders that are consulted. You can say victim compensation. They have not interviewed judges. I am going to interview judges also. Somewhere, unless you have a gap in literature, we should not be doing it. What I will try to do is maybe I'll send some model literature reviews, and that can be circulated to the students.
Yes. Secondly, in title itself, since I make it a point that since they are the PG student, they have to be very clear about the legal framework of the topic, because poverty
Yes,
is a purely social topic.
social concept. True.
Illiteracy is a total social topic.
Social
So
talk.
they have to keep it in mind that social legal research, the legal framework has to be there, especially for the LLM students.
Exactly. And we used to say that, are we political science students? No. Are we sociology students? No. We are law students. We are supposed to discuss law. And when we are framing a title, the approach has to be upside down pyramid approach. It should start from broader, it should end narrower, and it needs to have one way we can take care of this issue is that you add legal study to the phenomena or critical legal analysis or comparative analysis of legal systems. These three are very popular methods. I understand that initial phases of a student, but once you may not be understanding the methodological aspects, etc. But if you have these three or any of these three, of course, any of these three, if you put in your title, it makes as a legal study, and eventually you end up also doing a legal study. So if you talk about poverty and crime, you add somewhere a legal study of or a legal analysis, a critical legal study, something like that, and it will take care of it. But of course, you need to have law. We are law students. We are not political science students. We are not sociology students. We need to have legal study of it. Should there be a law and act mentioned in the title? No need. You need not. But there has to be
No, no.
some.
Let
Uh,
us since they are at the primary level of the research, the LLM
yes.
students, it will be better for them to write specifically if they are right to information or right to education, 21B.
Yes.
Let them write because it is their
Yeah.
initial stage. It is their
Yes.
initial
Yes. Of
stage.
course. Okay, so, of course, if you are writing well and good, this issue is taken care of. You have to be very careful if you are not writing the name of the law, the words that you use. At the end of the day, ensure that each word that we used in the title is capable of being defined or has already been defined or interpreted by judiciary or by law. We should never use a word in a title that has not been legally defined, because then the onus will fall upon you, and law can have different meanings. So use words which have been interpreted, defined, and law properly defines to be on safer side. And of course, a scope of Section 14 under Arbitration Act, can it be a good title? A legal study of Section 14 or scope of this thing. Of course, it can be a critical legal analysis of article Section 14 of Arbitration Act. Of course, it's a good topic of research. Or Section 66A of IT Act.
And they
Of
should
course,
have
that
a,
can be.
sorry to interrupt, they should have a scope for their field work also because this is a project.
some responses have to be collected. And no research, good research journal these days is accepting a research that is devoid of. It's okay. We are students, 10 interviews. It's not that difficult. Prepare a Google form, send it to 10 stakeholders, crucial stakeholders, and collect data from them. These days, Google spreadsheets, when you collect data in it creates pie diagrams, pie charts, bar graphs, etc. So in a ready-made fashion, ready-made manner, it also gives you interpretations and analysis of data. Plus, to some extent, we can take help of generative AI also for this. However, the statisticians are cautioning that you should not totally rely upon generative AI. But yes, you can take help of generative AI. Very rightly, Madam has pointed, you have to have some empirical research, 5 to 6 interviews, do some case studies, create a Google form, send it to your batchmates, send it to your stakeholders. If not, go to the court, observe the proceedings, whatever your topic of research is, have an empirical aspect to it. Uh, Take some sampling method that is relevant for your data collection. Take a proper tool of data collection and collect the data, code it, interpret it, analyze it. Tools are there, statisticians can be approached. Google Sheets does the half of the job, but empirical aspect, without empiricism, legal studies are not being accepted. You cannot study law without an empirical aspect to it. So something or the other, focus group discussions, that is also there. Go to the police station, tell them that I want to have a focus group discussion of 5 to 6 policemen. Take their permission, take a letter from the college, go over there, have a focus group discussion with them. One of the best ways of having is that when you have called people for seminars and conferences, you have ready-made audience available. And you can just ask the questions to them. Online meetings you can conduct. You can do a WhatsApp conference call. We have done that. We have done WhatsApp conference call, and it's not advisable. But I remember at one phase I was finding it very difficult to collect data, some data about police. I called 100, and it's not advisable, but I did collect. So innovative ways of collecting empirical data. Be as innovative as you can in collecting the empirical data. So mostly the popular ones are focus group discussions, interviews, observations, and uh, of course surveys through Google Forms these days. You have so many applications that will generate results for you, that will generate findings for you also. So tools are there. We can use those tools, but very important is empirical aspect. Whosoever, if you're doing on poverty, interview 5 poor people. If it's on victims, 5 victims. But yeah, that is how we'll come to know how law exactly works in field. It is not how it's in
A
books.
few PhD scholars are there. For them, the data number has to be sumptuous because only
It
five,
has to
six
be, yes.
won't be suffice to come to the conclusion. Few research scholars are there in the group.
100,
They have,
100. It
yes,
is
yes.
safe. Safe is 100. Safe is more than 100. You have to have, especially you have Google Forms available these days. You can meet and interview people. In our university, uh, we at least expect more than 100. And you have the option of dividing your stakeholders. You have 5 to 6 stakeholders. You have police, you have judges, you have lawyers, you have NGOs, you have You can go to politicians, you can go to students, you can, depending upon what your research is. But you need to have, some of our researchers have done 150, 200 responses. See, uh, uh, we cannot generalize something on the basis of 5 responses or 10 responses. This research that we do is for generalization. We have collected data, we have tried to look for some pattern. How can we look for a pattern if we just have collected 10 responses? There is no pattern to look into. And on the basis of pattern that is observed from 100 collected responses, then we propose some theory or we tend to test our hypothesis. But there has to be 100, 150 responses to test our hypothesis, to look out that pattern or even to propose the theory. And those 150 responses, as I again told you, need not be from one stakeholders. You divide your stakeholders depending upon what your topic is. Okay? Depending upon the accessibility. Let's say police is more accessible to you. That's fine. Take more interviews of police. Prisoners are more accessible to you. In a sense, you have good rapport with prison administration. Increase that number of stakeholders. But overall, of course, there has to be some rationale when it comes to keeping numbers of different stakeholders. It has to have, if you're a PhD scholar in our university, we do not have less than 120, 140, 150. We have to have that. My research student is doing a research on intellectual property during import, export, and transit of goods. It's a very niche area of research. 66 custom officials he has interviewed, despite being a very narrow and very niche area of research. In IPR violations, but during just import, export, and transit. I'm finding difficult for the examiners also for him now. But he ended up collecting 66 custom officials. He interviewed them. And then he interviewed the traders who are into import, export, and transit business of goods, 20 to 30. So yes, there has to be 100, 150. Otherwise, it's all bookish affair. The research has no relevance. There would be no crucial suggestions coming from you. We can go to the extent and say that you even have not understood what the research is unless you have known from the stakeholders what is exactly happening on the ground. So it has to be there. And it's a skill that you develop. This is a skill of a researcher, has to gather more number of responses. How can I get more? Snowball sampling method. Go to one person, get a name of another respondent from him, then to a third, then to fourth, then to fifth, then to sixth. Keep on jumping from one respondent to another. One crucial thing, and I will end it over here, is you might say that, sir, you are asking for us to collect 100, 150 responses, and you say, sir, we can categorize different stakeholders. Now, here's a trick that I'm giving to all of you. You can have different sampling methods for different stakeholders. I am not saying it has to be a purposive sampling for all of them, or probability random sampling, or a random sampling method for all of them. No, you can have 10 different stakeholders for 10 with 10 different sampling methods. You can use purposive for judges because it's difficult to reach out to judges, and you can use random sampling method for other stakeholders whose accessibility is easier for you. So this is a very crucial input I'm giving you. Have 6 to 7 different stakeholders from different 6 to 7 type of communities, categories of people from where you can collect your responses for your PhD. Employ different sampling methods for them, but cross that number where you can draw a successful generalization. You cannot generalize your findings on the basis of just 5 to 10 responses.
Okay, thank you so much, Dr. Anand. Your scholarly discourse here today. Since today we have PhD as well as few PhD and most of them are LLM PG students, and their synopsis we have gone through. So we thought that they really need some guidance, and it is better सोनार आणि कान टोचलेले बरे राहतात. म्हणून मग आम्ही तुम्हाला बोलवायचं ठरवलं. डॉक्टर आनंद, तुमचं जे रिसर्च आहे, डॉक्टर आनंद हॅज submitted his research to NHRC, then ICSSR, and he was succeeded to get the funding from all those things. So perhaps his discourse might have been a very high level of for you for the PG students, but I think that I'm going to ask few questionnaires, few questions. I'm going to float on the LLM group that what are the answers you have to reply them, and then you start your synopsis. We might not get on time, but we expect you to do sincere research work. And even the PhD scholars, those who are submitting, the last date is 2nd of October for submitting their synopsis. Kindly go through all the synopses, all the sequences. Some people write review after the hypothesis, some people write that is not correct. So you need to know as a research scholar what are the different steps of research meticulously. And then, so these efforts were done specifically to convey you that there is a typical methodology for the research. And why? Because Dr. Anand has approved research experiences. His Palghar rehabilitation experience was fantastic. He also studied on the women police from Maharashtra's, and then on various
For
segments, on
for
various
for
subjects.
for
Right.
Palghar, madam, sorry to interrupt you. Our research was appreciated by Bombay High Court. It was
Okay.
Bombay High Court that led us. They told us to conduct a research in Palghar district, which was affected by Tarapur power plant. And the people who were rehabilitated there, resettled over there, they said that we have not gotten as per land compensation law what we were supposed to get. We have not been properly rehabilitated. Government said we have done it. So there was a public interest litigation filed. Bombay High Court wanted to know the truth. So we conducted the research on behalf of Bombay High Court Legal Service Authority, and we generated a report. We presented the report, and on the basis of that report, a compensation of 5 CR was awarded immediately on the day on which we presented that report. So, can research bring some justice? Can it have some relevance?
It should have
It can
outcome
have.
also. It should have
It
outcome.
should have an outcome also. And because it was submitted to the court, we could not publish it. But after 2 years, we again conducted a research, and we published the report. So and one more instance I would share is that what from where madam comes is that unless you have that hunger for doing a qualitative research, you will not get it. It is not an exercise just for the sake of doing it. It's not a formality. I remember madam's research was pertaining to children, and I was doing internship in uh, in National Commission for Women, and on the way back, she had categorically instructed me. Her PhD was done. There was no need for that. She had already written papers. There was no necessity for that as such. But no, because of curiosity, because of her hunger for this thing, she said, Anand, I called madam. I said, madam, I'm coming from Delhi. What should I bring for you? Some sweet or something. He said, don't bring anything for me. Bring those NCW reports. I want to read their recent empirical studies. I want to read their child study reports. I want to read about sexual harassment, how gender is working over there, women studies. And I brought plethora of reports. I still remember I handed over to her and she went through all of them categorically. Was there any need? Was she doing her PhD? No, the PhD was ended. She was, in fact, guiding PhD students. But yeah, so this research hunger, this research has to be there. This emotion about,
Unfortunately, in our area, student do research to get the 100 marks, and the PhD scholar do it for getting the degree. It is very unfortunate, but the reality.
yes, and that should not be the case.
So that is
That
why
should
I
not be the
wanted you to speak to them and then convey them what real research is. So you have really given justice to the
right,
topic,
right. Yeah.
the intention and the objective of this discourse. I thank you from bottom of my heart. And even
Thank you.
if you have any queries, any help, Dr. Anand is
Sure.
always ready to help for the
Anytime.
academic cause. Yes, I'm sure about it.
Sure.
With
I
this
will
note,
share my
yes,
email address.
yes,
They
yes,
can
yes.
anytime, anytime.
Yes, yes. Thank you for your valuable time and cooperation. Looking forward the same in future. Thank you so much.
Sure, sure, ma'am. Thank you.
Yes.
Thank
Thank
you,
you.
sir. Thank you, ma'am.
Thank you.
If you have any query, PhD scholars, you please contact Dr. Anand because he has a vast knowledge in research. In empirical, that is
Sure,
not.
ma'am.
Yes, yes, yes. Yes. Now
I have
over to.
written
So,
my email address in the chat box also. If people want to reach out to me, they can.
Over
In the
to
chat
Dr.
box.
Sandeep Wankhede, sir, for the vote of thanks.
yes, yes. So it's a time. The time has come that the lecture was supposed to be of 1 hour only, but Dr. Anand sir has given us lots of information in a very precise manner and in a very easy way. So that could be very beneficial for us, sir. So uh, we it would be very difficult. It would not be fair that if we don't propose vote of thanks to you. So, on behalf of Dr. Punjab Law College of Law, Amravati, I extend my heartfelt gratitude to our eminent speaker, Dr. Anand sir, for giving this occasion with your presence and inspiring words and explaining such a hard topic in a very easy manner. So I sincerely thank to our respected principal, Dr. Varsha Deshmukh Madam, for their constant support and encouragement in making this what lecture a great success. And a big thanks to all the participants, the LLM students, the PhD scholars, and all who participated in today's session and showcased their presence and made this program lively. So, once again, thank you for everyone. Wishing you all a pleasant evening. With this, we declare that today's session is concluded, and with the permission of our principal ma'am, we will conclude this session.
Yes, yes. The session is
Oh,
concluded. Thank you so much. Thank you.
Thank you so much.
Yes.
so
Thank you. Thank
thank
you, sir.
you. Thank you.
Thank you so much.